Your license was revoked in 2002 and you kept
I
running
manage
the clinic.
operations here. The clinical side is handled by Delanco.
You used runners to bring in patients, including people who stage crashes.
This clinic serves accident victims. I built this to help people.
Once is a mistake, twice is suspicious. Philip Patacco ran this operation for 5 straight years across hundreds of fraudulent claims and left a paper trail for every single one.
$4 million in claims billed under a license that is not yours.
I need my attorney before this goes any further.
The confrontation you just watched was 5 years in the making. Philip Patacco was 65 years old, a former chiropractor from Kinnelon, and the man detectives were escorting out of the South Orange Trauma and Rehab Center had not held a valid New Jersey chiropractic license since 2002. For nearly a decade and a half, he had been treating patients, billing insurance, and running the clinic anyway. By the time the Office of the Insurance Fraud Prosecutor closed the file, investigators had traced nearly $4 million in fraudulent claims funneled through a single account, staged car crashes recruited by paid street runners, and a licensed chiropractor whose name sat on every document while Patacco quietly ran everything behind him. Before we go any further, I have to ask, if you found out the chiropractor adjusting your neck lost his license 16 years ago, would you still walk back through that door? Drop your answer in the comments. And if you're new here, subscribe now. We cover cases like this every single week, and the details in this one only get worse from here. Philip Patacco was born in the early 1950s in northern New Jersey to a working-class family that valued tradition, hard work, and the American promise that a professional degree could lift a son one class up from where his father started. His father worked in the trades. His mother kept the house and later took a part-time job at a local pharmacy. Neither of them had college educations, and both of them wanted more for Philip than they had for themselves. He was, by every account of the people who knew him growing up, an ordinary kid. Quiet, studious, not the star athlete, not the class president, but the boy who did his homework, who helped his mother carry groceries, who never gave his teachers a reason to complain. His grades were consistent, if not spectacular. His discipline was. He graduated from high school in the early 1970s and enrolled at a state college in New Jersey, where he took the science-heavy coursework required for admission to chiropractic school. The chiropractic profession was, at that time, going through a significant institutional transition. Once dismissed by mainstream medicine as fringe, it had been steadily gaining state licensing, insurance coverage, and professional legitimacy through the 1960s and 1970s. Philip was drawn to the field for reasons both practical and personal. His mother suffered from chronic back pain. A local chiropractor had provided relief when medical doctors could not. Philip decided he wanted to do the same for others. He attended a chiropractic college in the mid-1970s, graduated in the early 1980s, and passed his New Jersey state licensing examination on his first attempt. He was, at that moment, everything his parents had hoped he would be. A licensed professional, a doctor of chiropractic, a man with letters after his name and a diploma on his wall. He opened his first practice in a small storefront office in northern New Jersey in the early 1980s. Rent was reasonable, overhead was low. He drove a modest car, worked 6 days a week, and slowly built a patient base of neighbors, referrals, and word-of-mouth clients who trusted the young chiropractor with the calm bedside manner and the reasonable fees. He married in the 1980s. He and his wife bought a house in Kinnelon, Morris County, a leafy suburban borough tucked into the hills of northern New Jersey, where the streets are quiet, the lawns are wide, and the property taxes are among the highest in the state. It was a good place to raise a family. It was a good place to be a doctor. He fit the community. The community fit him. Through the 1980s and into the 1990s, his practice grew. He hired staff. He expanded his services. He took continuing education courses. He was elected to a local business association. He coached a youth sports team for a season or two. His wife decorated the house for the holidays every year with a wreath on the door and lights along the shrubs. Their neighbors waved to them at the mailbox. But something began to change in the late 1990s. The specifics of what went wrong professionally would not become fully public until years later, But the trajectory of Philip Pataco's career took a hard turn. The New Jersey Board of Chiropractic Examiners, the state regulatory body responsible for overseeing chiropractic practice, opened a review of his conduct. The review resulted in disciplinary proceedings. The proceedings resulted in findings. And in 2002, after a formal administrative process, the New Jersey Board of Chiropractic Examiners revoked Philip Pataco's chiropractic license. Revoked. Not suspended for a period. Not restricted. Not placed on probation. Revoked. The strongest disciplinary sanction the board can impose. An institutional determination, made after a formal process, that Philip Pataco was no longer fit to practice chiropractic in the state of New Jersey. He was 49 years old. He had built his entire adult identity around being a chiropractor. And in the eyes of the state of New Jersey, that identity was now permanently over. For most people in his position, the story ends there. They pivot. They retrain. They take a job outside the profession. They accept the finding and rebuild. Philip Pataco did not. To understand what Philip Pataco did next, you have to understand three things about how the chiropractic industry works in New Jersey. The first is licensing. Chiropractic is a licensed profession, regulated at the state level by the New Jersey Board of Chiropractic Examiners under the umbrella of the State Division of Consumer Affairs. To adjust a spine, to render a diagnosis, to represent yourself to the public as a chiropractor, you need a valid, active license issued by the board. Practicing without one is a criminal offense under New Jersey law. When a license is revoked, the practitioner is legally barred from providing chiropractic services for compensation, and any facility that holds itself out as a chiropractic office is required by New Jersey law to be under the ownership and control of a licensed chiropractor. The second is billing. Chiropractic services are covered by most private insurance carriers, by workers' compensation, and, critically, by the personal injury protection benefits mandated by New Jersey's no-fault auto insurance law. Every driver in New Jersey is required to carry personal injury protection coverage, or PIP, which pays for medical treatment following an automobile accident regardless of who was at fault. PIP claims are lucrative for chiropractic clinics because auto accident injuries, particularly soft tissue injuries like whiplash, respond well to sustained chiropractic care, and because the insurance carriers are legally obligated to pay for medically necessary treatment. A single accident patient can generate thousands of dollars in billing over the course of a treatment plan. A clinic that specializes in accident patients can generate millions. The third is the referral network. New Jersey, like most states, has strict laws prohibiting what the statutes call running, capping, and steering. A runner is a person paid to solicit accident victims and steer them toward specific medical providers, chiropractors, or personal injury attorneys. The practice is illegal because it corrupts the medical decision-making process, inflates claim volumes, and creates financial incentives for treatment that is not medically necessary. New Jersey's anti-running statute imposes criminal penalties on both the runner and the professional who hires, directs, or employs the runner. The law exists precisely because the combination of no-fault insurance coverage, high claim values, and vulnerable accident victims creates an environment ripe for exploitation. Three structural safeguards: licensing, billing oversight, the anti-running statute. Together, they are supposed to make the chiropractic industry safe for patients, honest for insurers, and closed to the kind of predator who sees an accident report as a sales lead. Philip Pataco found a way around all three. The mechanism was simple in concept and disciplined in execution. Pataco needed a licensed chiropractor, not a partner, not a colleague, a name, a face, a signature. Someone with a valid license from the New Jersey Board of Chiropractic Examiners who was willing, for a salary, to allow that license to sit on top of a facility that Pataco actually ran. He found one, a licensed chiropractor from Sparta in Sussex County. That chiropractor's role, for the purposes of this episode, is limited to necessary context. He was the licensed name on the paperwork. He appears on the corporate documents. He appears on the billing forms. He appears, on paper, as the owner and treating provider of the facility that would become the center of the scheme. The facility was called South Orange Trauma and Rehab Center, SOTC for short. It opened in South Orange, in Essex County, a mid-sized New Jersey township with easy highway access, a diverse patient population, and enough surrounding auto traffic to keep an accident injury practice busy year-round. On paper, SOTC was a straightforward chiropractic clinic owned and operated by a licensed New Jersey chiropractor. The signage was appropriate. The corporate filings were appropriate. The insurance credentialing was appropriate. Everything a regulator or an insurance carrier would look at on the surface appeared to be in order. In reality, Philip Patacco ran the place. He made the operational decisions. He controlled the finances. He hired the staff. He set the treatment protocols. He negotiated the rent. He answered to no one. And, most critically for what would follow, he directed the referral pipeline that filled the treatment tables week after week. That pipeline was where the second layer of the scheme lived. Patacco used runners, not one runner, a network of them. Individuals paid to solicit accident victims and direct them to SOTC. The economics of the arrangement were straightforward. A runner would identify a person who had been in, or claimed to have been in, an auto accident. The runner would approach that person, sometimes at the scene, sometimes at a body shop, sometimes at a tow yard, sometimes through a chain of introductions that could be traced back to a specific network of contacts. The runner would tell the accident victim that they needed treatment, that they were entitled to it, that a specific clinic would take good care of them, and that the clinic would handle everything with the insurance company. The runner would receive a fee for each patient delivered. The clinic would collect the insurance billing. For legitimate accident victims, the arrangement violated the anti-running statute, but at least produced treatment for real injuries. For the other category of patients, it did something worse. Some of the patients recruited into SOTC had staged their crashes. Staged crashes are not accidents. They are performances. A group of participants agrees in advance to fabricate a collision. Two vehicles collide at low speed in a controlled location. The occupants file police reports. The occupants file insurance claims. The occupants report injuries. The occupants seek treatment. The occupants collect settlements. Every participant plays a coached role. The runner brings the participants to a clinic willing to bill for treatment that either did not happen or that treated injuries that did not exist. Patacco's runners brought staged crash participants to SOTC. SOTC billed the insurance carriers for those patients. The billing forms used the straw owner's name, the straw owner's license number, the straw owner's credentials. The claims moved through the personal injury protection system. The insurance carriers paid. Between 2010 and 2015, a 5-year window during which this architecture ran continuously, approximately $3,991,812 in claim money was funneled into SOTC's account. Nearly $4 million on billing that carried a licensed chiropractor's name and a facility that a revoked, unlicensed man actually controlled. The New Jersey Office of the Insurance Fraud Prosecutor is not a general-purpose law enforcement agency. It is a specialized unit within the State Attorney General's office, created specifically to investigate and prosecute the kind of scheme that Philip Patacco was running. It has its own detectives, its own attorneys, its own forensic accountants, and a caseload built around the exact structural pattern that SOTC represented. Straw ownership, runners, staged crashes, inflated billing, fraudulent PIP claims. The precise mechanism that surfaced the SOTC file has not been publicly detailed. What is known is that by the mid-2000s, the OIFP was building a broader enforcement priority around exactly this category of scheme, and that multiple factors converged to draw investigative attention to South Orange Trauma and Rehab Center. One factor was the claim pattern. Insurance carriers, particularly the larger PIP writers in New Jersey, run analytics on their claim data. When a single small clinic bills millions of dollars in personal injury protection, claims year after year, when the claims cluster around a small set of referring runners, when the treatment plans follow suspiciously uniform templates, when the diagnoses skew toward high-value soft tissue codes, the analytics start to flag the facility. Analysts inside the carriers pass their findings to their special investigation units. The special investigation units, when their findings meet a certain threshold, refer to the OIFP. A second factor was the licensing record. The New Jersey Board of Chiropractic Examiners maintains records of every license revocation. Philip Pataco's 2002 revocation was in that record. If any part of the OIFP's investigative work, or any parallel work by the board itself, connected Pataco's name to SOTC, the licensing history became instant probable cause to look deeper. A revoked chiropractor showing up in the operational orbit of a chiropractic facility is not a coincidence. It is a red flag the size of a highway sign. A third factor was the runner network. Anti-running enforcement in New Jersey involves cooperators. Runners who get caught in one investigation are frequently willing to trade information about the clinics they worked for. Accident victims who get pulled into fraudulent claims sometimes decide, when confronted with their own criminal exposure, that a cooperation agreement is preferable to prosecution. Somewhere in that network of cooperators, information about SOTC and about the man who actually ran it flowed into the OIFP's file. By the time the investigation matured, OIFP detectives had assembled the 6 pieces of forensic architecture that would ultimately support Pataco's guilty plea. First, the Board of Chiropractic Examiners records establishing the 2002 revocation. Second, the SOTC corporate documentation establishing the licensed chiropractor as straw owner on paper. Third, operational evidence, whether from surveillance, from cooperators, or from documents seized during the investigation, establishing that Pataco was the person actually running the facility. Fourth, evidence of the runner recruitment network and the staged crash participants who moved through it. Fifth, the insurance claim records showing the roughly $4 million funneled into SOTC's account using the straw owner's billing credentials. And sixth, the investigative reconstruction that connected all of it into a single, coherent, 5-year criminal enterprise. We are about to head into the arrest and the courtroom. If you have made it this far, that means the story has your attention, and you already know this channel is different. Subscribe if you want to see exactly how the state of New Jersey handles a case like this one. The sentence at the end is going to surprise you. Insurance fraud cases at this scale do not close in a single dramatic morning. They close over months, sometimes years, of paper, bank records, subpoenaed billing files, grand jury testimony, sealed indictments, witness interviews conducted in county prosecutors' offices with recording devices running and defense attorneys taking notes. The OIFP investigators moved methodically. They pulled every insurance claim SOTC had submitted between 2010 and 2015. They cross-referenced the claim dates against police accident reports. They cross-referenced the accident reports against the addresses, employers, and social networks of the patients named on the claims. When patterns emerged, they pulled the phones. When phones connected patients to runners, they pulled the runners. When runners connected back to SOTC, they pulled SOTC's payroll, SOTC's bank statements, SOTC's lease, and every corporate filing tied to the facility's ownership. The bank records were, in many ways, the spine of the case. The approximately $3,991,812 in claim money that flowed into SOTC's account left a trail. Every deposit had a claim behind it. Every withdrawal had a signature or a wire instruction behind it. Investigators traced the money out of the facility account and into the operational orbit of the person who actually controlled the funds. That person was not the licensed chiropractor whose name appeared on the corporate documents. That person was Philip Pataco. Interviews with staff, with former patients, with runners who had accepted cooperation agreements, and with the licensed chiropractor whose name sat on top of the operation, all pointed in the same direction. The person who made the operational decisions at SOTC, the person who set the schedules, the person who approved the hires, the person who handled the vendors, the person to whom the office deferred. That person had lost his chiropractic license in 2002 The staged crash dimension of the case added a further layer of evidentiary weight. When investigators identified specific accidents in the SOTC claim record that carried the signatures of staging, low-speed impact on a residential street, multiple occupants, each with soft tissue complaints, treatment plans initiated within hours of the accident, they pulled the participants in for interviews. Some of those participants cooperated. Their accounts confirmed what the paper record already suggested. They had been recruited by runners. They had been directed to SOTC. They had been treated, or billed as treated, by a facility whose actual controller was a man with no license. By the time the OIFP was ready to move, the investigative file had grown to a size that made a defense on the merits functionally impossible. The evidence was documentary. The corroboration was multi-witness. The financial trail was traceable to the dollar. And the licensing history sat at the top of the file like a stamp on every claim. The arrest itself was not the drama of the case. By the time detectives arrived to formally take Philip Pataco into custody, the investigation was long over. The grand jury had returned an indictment. The Attorney General's office had approved the charges. The defense attorneys had already been contacted. What remained was procedure. Pataco surrendered through counsel. He appeared in Morris County Superior Court for his initial proceedings. He posted whatever conditions were set for his release. He returned to his home in Kinnelon. He waited. In the months that followed, his attorneys negotiated with the state. The negotiations covered the counts, the sentencing exposure, the restitution figure, and the language of the plea agreement. The state had leverage. The evidence supported a trial conviction on multiple counts. A trial conviction, given the second-degree exposure attached to the money laundering count alone, could have produced a sentencing range substantially more punishing than what the state was willing to accept in exchange for a plea. In November of 2017, Philip Pataco walked into a courtroom in Morris County Superior Court and pleaded guilty to 3 counts. Second-degree money laundering under New Jersey Statute 2, C-21-25. Second-degree official misconduct under New Jersey Statute 2, C-30-2. And third-degree practicing chiropractic without a license. There was no explosion in that courtroom. There was no denial. There was no attempt to justify. The plea colloquy required Pataco to allocate to the specific conduct underlying each count, to acknowledge that his conduct was knowing and voluntary, and to accept that the state's factual basis supported the plea. He did. He answered the judge's questions in a quiet voice. He confirmed that he understood the consequences. He confirmed that he was pleading guilty because he was, in fact, guilty. He confirmed that no one had promised him anything beyond what was written in the plea agreement. He confirmed that he understood he was giving up his right to a trial. The plea was accepted. The court set a sentencing date. Philip Pataco walked out of the courtroom that afternoon, a convicted felon, awaiting only the calibration of the number of years he would spend in a New Jersey state prison. The sentencing took place on April 6, 2018, before Judge Thomas J. Critchley in Morris County Superior Court. The courtroom that morning contained the usual cast: the Deputy Attorney General assigned to the case, defense counsel, court staff, a handful of observers in the gallery. Somewhere in the room, or reflected in the papers on the judge's bench, were the interests of the insurance carriers that had paid the roughly $4 million in fraudulent claims. Somewhere in the record were the names of the accident victims, legitimate and staged alike, who had moved through SOTC over the course of 5 years. The state's position framed the case as one of the more egregious insurance fraud prosecutions in the OIFP's recent docket. Attorney General Christopher Perino, whose office had brought the initial charges, had described Pataco publicly as the mastermind of an elaborate criminal enterprise. By the time of sentencing, Gerbier S. Gruel had succeeded Perino as Attorney General, and Gruel's statement at the conclusion of the case framed the institutional stakes. Patients must be able to trust their doctors and the information their doctors provide, Gruel said. When a doctor lies about the status of his medical credentials, the ownership of his chiropractic practice, And the details of his insurance claims, he betrays that trust. The lengthy prison sentence this defendant received underscores our commitment to eradicating this kind of criminal conduct from New Jersey's healthcare industry. Judge Critchley delivered the sentence: 7 years in New Jersey State Prison, $3.5 million in restitution to the various insurance companies that had paid the fraudulent claims. The counts ran concurrently under the terms of the plea agreement. The second-degree money laundering charge, the highest-degree money laundering exposure in New Jersey state law, anchored the sentencing range. Philip Patacco was 65 years old on the day he was sentenced. He had been a chiropractor once. He had lost that identity in 2002. And instead of accepting that loss, he had spent the next 13 years building a shadow version of the career the state had taken from him. He had rented a licensed chiropractor's name. He had recruited patients through runners. He had billed insurance carriers for treatments that in some cases treated injuries that had never happened. He had funneled nearly $4 million through a facility that was, on paper, not his. And now, at the age of 65, he would enter the New Jersey state prison system to serve 7 years for a scheme that the state had determined he had personally masterminded. The institutional questions that the case raised are the questions the New Jersey Insurance Fraud Enforcement Docket continues to work through today. How does a licensing board's revocation actually stay enforced when a determined former licensee can rent another professional's name? How does the anti-running statute reach the networks that recruit staged crash participants alongside legitimate accident victims? How do carriers detect straw ownership faster? How does a state deter someone who has already lost his license from spending the next decade circumventing the loss? The Patacco case is one data point in the answer. 7 years in state prison, $3.5 million in restitution, and a public record that will follow the name Philip Patacco for the rest of his life. He had every warning. He had every off-ramp. In 2002, when the board revoked his license, the state told him, in the clearest institutional language available, that his career as a chiropractor was over. He heard that determination, he understood it, and he decided, deliberately and repeatedly, over the course of the next 13 years, to act as if it had never happened. The Board of Chiropractic Examiners was right about him in 2002. It took the Office of the Insurance Fraud Prosecutor another 16 years to prove it. This case was calculated, but the case on the right-hand side is on another level of shameless. Click it now.